Good afternoon. Thank you to Professor Gervais and to JetLaw. Thanks to all the students who organized, and I really appreciated the pickup at the airport. That was a very nice touch, so thank you very much. It's my first time to Nashville, and I'm enjoying it so far. So I'm going to actually talk about something a little bit different. I am going to be talking about corporate social responsibility as it relates to IP, and so not directly talking about ISDS, but talking about IP and human rights more broadly. There's an ISDS connection that can be made, but that's not the focus of this talk. So I think about trade-related IP and what we protect under the current international system. And I think about what I call cultural IP and how it relates to human rights and to international trade. So this first slide is just your typical IP that we're all familiar with, like the Nike logo or the Apple iPhone, Disney's Mickey Mouse, and these are all things that are protected at international law. And then I have a second slide, which is cultural IP that is from Ghana. So I call this cultural IP from Ghana because it is intellectual property under Ghana's domestic laws. So we have an adinkra symbol, which is the little symbol that is on it's a big symbol here. It's the black one, the horns rams. And it was reproduced on this backpack by Vera Bradley. And so some Ghanaians saw it, and they were outraged that why is the adinkra symbol reproduced on this backpack that is being sold by a corporation in the United States. And there must be some way, people said there must be some way that we can stop this. There must be some sort of intellectual property law that applies. But as we know, it is not protectable. So even though we have the adinkra symbol and the kente cloth, some of you are probably familiar with kente cloth. People use it a lot here in the US for different kinds of celebrations. Also part of Ghanaian cultural heritage, protected under Ghanaian copyright law, but not here. Not used in commerce, so not protectable as a trademark, not protectable under copyright law through the Byrne or TRIPS because the works are too old to receive protection. So this is what I would call border crossing IP. It's cultural IP, it's trade related, and the question becomes why protect one? So we'll protect this, but not this. It's a question of values, right? Each has limits. One is commercialized, the other is not commercialized. One is owned by corporations, the other is not owned by corporations. And if you protect cultural IP like this, like the adinkra symbol and the kente, it could help promote the human rights of the affected group without necessarily interfering with corporate profits. If you protect corporate IP, it does boost profits, but it doesn't necessarily promote or protect human rights. So Nike is valued and Mickey Mouse is valued because they have some economic value. They're worth a lot of money. They're protected under Byrne and TRIPS. And this is the default, but it doesn't mean it has to be the default. And arguably, there's a gap in the international legal regime. So some of you may be aware that there's been this move at the World Intellectual Property Organization to protect this intangible cultural heritage for quite some time. But it's been going on for several years without any progress. And this is where I think corporate social responsibility, which is related to human rights and based on human rights principles, may have a role to play. So there's a legal gap that can be perhaps filled by norms. So we just heard Professor Ho saying that the bringing in human rights law doesn't necessarily work, but norms can make a difference. And there are a couple of reasons why I'm thinking about the corporations rather than the institutions or the legal decisions as we've been talking about today. The corporations, many of these multinational companies, they're very wealthy, they have more money than states, and that's the reason for the whole corporate social responsibility movement in the first place. Often, corporations are the bad actors. When we talk about intellectual property and access to intellectual property and human rights, the bad actor that we're normally looking at is some corporation. And in many ways, international intellectual property has operated in ways that run counter to what the corporate social responsibility movement is trying to do, which is why we hear about this upward ratchet, having more and more IP protection, higher standards, longer terms. And when we look at who owns a lot of the IP, it's corporations. So corporations have a huge role to play. They own a lot of IP. We've just heard talk about how they intimidate countries, whether it's through ISDS or other ways. They can actually influence what countries are doing. So from Eli Lilly to Australia plain packaging, even if these nations win, they still have to expend tremendous resources to fight back against what the corporations are attempting to do. So in light of their significance on the global stage and their impact, the CSR movement calls on corporations to act in accordance with human rights principles and to go beyond what the law requires. So the countries, nation states have the obligation to protect human rights. States also have obligations to protect intellectual property, and corporations are not directly obligated, arguably, they're not directly obligated, but we have this idea that they do have some responsibility, and what you have up here on the slide, which is the last slide, are these guiding principles on business and human rights. And there are a lot of different documents out there about corporate social responsibility and what corporations should be doing, but I chose just this one. Corporations, as major owners of intellectual property rights, have to manage their IP and their IP-related activities in ways that promote respect for human rights. So this is why I think CSR has a role to play. Normally, when people talk about CSR, they talk about things like oil spills and how it devastates communities in Nigeria and think about the environment. We don't typically think of intellectual property and corporate social responsibility. We don't typically think about the IP that corporations own as having an impact on human lives, yet they do in many ways, and you've already heard that today. From access to medicines to education. I chose culture because I think it's an interesting case and less typically discussed. I would argue that not protecting cultural IP can also have a detrimental effect on human rights. It's interesting to note that even at the International Criminal Court, they prosecuted somebody for the destruction of cultural property. And to the extent people want to make arguments that intellectual property is like tangible property, there is this protection for cultural property, for tangible cultural property in the international arena as well. Because often we want to say, let's not talk about this intangible cultural property. It's not a real thing. So what is the role for CSR, and what am I talking about when I talk about CSR here? So the definition that I'm using is actions that further some social good beyond that which is required by the law. So the focus is on norms and not on laws, even though the norms are based on human rights law. The idea is that corporations should protect, respect, and remedy human rights violations. And CSR asks corporations to respect human rights even when countries don't. Here, in the case of intangible cultural property or cultural IP, I'm not focusing on human rights abuses, but rather suggesting that corporate practices related to their IP should promote human rights and be guided by CSR principles along with the core theoretical objectives of intellectual property law. And I see CSR and the human rights framework for IP coming together to the extent that IP is used to promote progress and human flourishing. So for example, rather than just using whatever protected cultural symbol is out there, CSR, good corporate practice, would require the corporation to consult with the relevant corporate community, with the relevant community, and possibly partner with the community. So again, this is not laws, but norms. CSR would require prior informed consent. CSR would mean that in the event of a conflict between an IP right and a human right, say access to food, the corporation would recognize that the human right should prevail. Because when we pit IP rights against human rights in the legal sense, IP tends to win. So I'm saying let's have the corporations take a greater role. So and bring the CSR movement into the IP sense. I'm going to wrap up shortly. So finally, the final point that I want to make is, or discuss, is what should guide corporations? What should guide corporate social responsibility as it relates to IP? So I would say there are the human rights laws, which I'll come to momentarily, but also the intellectual property goals, which I mentioned earlier. And to the extent that we can find IP goals as internationally agreed upon, we can look to the WTO TRIPS agreement, in particular Article 7, which speaks to IP contributing to the promotion of technological innovation, the transfer and dissemination of technology to the mutual advantage of users and producers. So there's that balance that's there. And also, I would point to IP theories, which generally talk about incentivizing innovation and creation, but to what end? To promote progress, to promote human progress. So I would suggest that that's one thing that can guide CSR as it relates to IP. And then from the human rights side, there are a lot of different human rights provisions one could draw on and say the human rights should guide corporations, but I would just mention a couple. One is the duty to the community. So you see here in paragraph 12, it refers to the International Bill of Human Rights, which is the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, which have various similar overlapping provisions. So Article 29 of the UDHR, which says that everyone has duties to the community, in which alone the free and full development of his personality is possible. There's a duty also not to eliminate the rights of others. We could turn also to, for instance, things like the Declaration on the Right to Development. And the last one that I'll mention is the United Nations Declaration on the Rights of Indigenous People, which says that Indigenous peoples have the right to maintain, control, protect, and develop their cultural heritage, and it expressly includes their intellectual property. So basically, what I'm saying in a nutshell is that some of these human rights instruments, they're aspirational. But if corporations and corporate social responsibility goals are used, you could bring international intellectual property law closer to its objective of promoting human flourishing and human development. So that is my presentation. I welcome any comments you may have. Thank you.